Welcome back to Cool as a Cucumber, how to testify successfully at your deposition or in court in a domestic relations case, Part 6, in which we discuss Deposition Golden Rule number 5. Before you answer, hear the question, understand the question. It is the questioning attorney's responsibility to articulate intelligible questions. If you do not understand the question, say so. Do not allow your pride to stand in the way of understanding a question. Don't let your fear of looking foolish cause you to answer a question you don't understand. You will guarantee you look foolish that way. It is not your responsibility, however, to help the attorney questioning you to formulate an understandable question. Do not answer a question that isn't asked. Do not ask the attorney, well, did you mean to ask this? Don't do that. That's deposition suicide. Right way. Question, do you have any children? Answer, yes. Question, how many? Answer, 2. Question, boys, girls? Answer, 2 boys. Question, are they minors? Answer, one of them is. Now let's assume you hear the next question as possibly meaning, do you know who your son's teachers are? Meaning both sons. Do you know who your son's youngest teachers are is actually the question, but you couldn't tell. Now you know the names of your youngest son's elementary school teachers. You're in the clear, but you have no idea who your adult son's college professors are, nor should you have any reason to. Now here's the question. Do you know who your son's teachers are? Answer, whose teachers? Question, your son's teachers. Answer, which son? Question, your youngest son Jimmy's teachers. Answer, yes. Question, what are their names? Answer, Mrs. Brown, Ms. Tuttle, Mr. Cheever, and Mrs. Watson. Here's the wrong way. Question, do you have any children? Answer, yes. Question, how many? Answer, 2. Question, boys. Girls? Answer, 2 boys. Question, are they minors? Answer, one of them is. Okay, so far so good. Now, you hear the next question as, do you know who both your son's teachers are, but was actually meant as, do you know who your youngest son's teachers are? It sounds the same to your ear. You know the names of your youngest son's elementary school teachers, but you have no idea who your adult son's college professors are. Now, here's the question. Do you know who your son's teachers are? Wrong way. Answer, all of them? No, why would I? See how dumb that makes you look? Now, it's the questioning attorney's responsibility to learn the facts. You are not required to volunteer this information without first being asked specifically by him to educate him or her in this endeavor. Even if the attorney acts, and it is acting, frustrated that you aren't being cooperative, do not volunteer information that is not sought by a specific question. If you are one of those who squirms during awkward silences in a conversation, don't speak up in your deposition just to fill the awkward silence. Attorneys often try to get you to divulge information that way. It's not rude to be silent in a deposition when there's no question pending. Keep your mouth shut until an actual question is posed. Now watch out for compound questions. Compound questions are 2 questions asked in the same sentence. Example, did you or your partner steal the money? Or, Mr. Smith, are you alleging your wife managed to place the house up for sale without your knowledge and show the house to potential buyers and close on the sale without you allegedly being present? Compound questions are scary because you may want to answer one part of the question with a yes or a no or I don't know, and another part with no or yes or I don't know. But if all you do is answer with a single no or with a single yes, the court might think you were answering no or yes to both parts or all parts of the question. Point out when you are asked a compound question by saying so, then ask the attorney to break the question into 2 separate or multiple parts that you can answer separately. It's your right. Right way. Question, did you withdraw the money from the joint account without your wife's consent? Answer, that's multiple questions in one. Please break them up. Question, now if you insist. First, how did you manage to withdraw all of the money from the joint account? Answer, that's still 2 questions. Question, fine. Did you withdraw all of the money? Answer, yes. Question, was it a joint account? Answer, no. Question, whose account is it? Answer, mine. It's an account I opened prior to our marriage. Wrong way. Question, did you withdraw the money from the joint account without your wife's consent? If you answer with yes, the judge might think you withdrew all the money from a joint account, which is not true. You look like a liar. If you answer with yes, the judge might think you withdrew the money without your wife's consent, which is not true because you didn't need her consent. If you answer with no, The judge might think you're claiming that you did not withdraw any money, when in fact you did. Even though you were trying to tell the truth, you can still look like a liar when it comes to compound questions. Learn how to tell the truth clearly and unequivocally. If a question is too complex or ambiguous for you to easily understand it, it is too complex or ambiguous to answer. Remember, you are in control of your responses. If the question contains conjunctions, and, or because, then ask the attorney to rephrase or break down the question. If the question uses words you don't understand, say so. If you're self-conscious about looking stupid by not knowing the meaning of a word, get over yourself and fast. One of a lawyer's most powerful weapons is the witness's own pride and/or insecurity. Give the attorney's words their literal plain English meaning as well. Having the attorney define words that are clearly understandable to the average person will make you seem evasive or obstructive when the testimony is read back or reviewed by the judge. Asking the attorney to repeat a question as a ruse for stalling is pretty obvious too, so don't do that either. If you need time to answer a question, take a brief, reasonable pause that you need and then answer the question. Do not overanalyze every question either. Let's examine the right and wrong way from a deposition of a U.S. president connected with a sex scandal. This was during Bill Clinton's presidency. Both the right way and wrong way examples will be coming from a part of the actual deposition of the president. Right way. This is what President Clinton should have done in response to this question. The statement that there was no sex of any kind in any manner, shape, or form with President Clinton was an utterly false statement. Is that correct? Answer. Yes. Now here's what President Clinton did, the wrong way. Question. The statement that there was no sex of any kind in any manner, shape, or form with President Clinton was an utterly false statement. Is that correct? Answer. It depends upon what the meaning of the word is. If is means is and never has been, that's one thing. If it means there is none, that's a completely true statement. You'll find this exchange from the deposition of President Clinton under the dictionary definition of too clever by half. My friend, regardless of your political affiliations, if you believe that the president's answer did his case any favors, then you are likely in trouble when it comes time for your testimony. Don't be too eager to anticipate questions from the attorney deposing you. Anticipating questions you think may be asked could result in you divulging information you would never have otherwise been asked to divulge. Right way. Question. Did you spank your son? Answer, yes. And then the attorney goes on, okay, well, I'd like to move on to why you want the family dog awarded to you, or something like that. Okay, you answered the question posed, no more, no less. This is the wrong way. Question, did you spank your son? Answer, of course I did, but only 4 times, not the 5 times my spouse claims. And I wasn't drunk when I spanked him. I'd only had 2 beers. That boy's lucky I didn't beat him senseless after what he did. And if he says I whipped him with a belt, he's lying. Repeat this orally to yourself. Do not overanalyze every question or be too eager to anticipate questions from the attorney deposing you. Thanks for watching or listening, and we'll see you back here for part 7.